Greetings, and thank you for joining today's webinar, the State Tax Impact of Altera. Before we begin, there's a few housekeeping items. At the bottom of your screen are some widgets. If you have any questions during the webinar, click the Q&A widget. We'll follow up with you after the program. At the resource list widget is a copy of the program slides. And if you have any technical difficulty, click the widget with a question mark. Recording will be available in a day or two and can be accessed by the audience link. With that, we will get to the presentation. Thanks again for joining. My name is Kyle Sollie. I'm a partner here at Reed Smith. With me today is Sebastian Watt, and we are state tax lawyers in the Reed Smith's Philadelphia office. Together, we're going to be discussing the state tax impact of Altera in the wake of the U.S. Supreme Court's decision not to review the Ninth Circuit Court of Appeals decision in that case. Now, we're not going to discuss much about the underlying merits of Altera, because that's been developed in detail by many other commentators. Instead, today we're going to focus on what your company should do today, right now, as a result of the Supreme Court's refusal to review the case. So let's start with the conclusion in mind. Who should be paying more tax now, today, as a result of the Supreme Court's denial of cert in Altera? Our answer is no one. No one should pay more tax today. This includes companies whose appeal from the tax court would be to the Ninth Circuit. This even includes Altera itself. In our view, not even Altera should pay more state tax, at least today, as a result of the Supreme Court's cert denial. So if Altera shouldn't pay more tax today, you certainly should not. So with that, I'm going to pass it back to Sebastian to discuss Altera.
Thanks, Kyle. So the issue in Altera involved transfer pricing between related corporations that entered into an agreement to jointly develop intangible property. Under a typical arrangement, a U.S. corporation enters into a cost-sharing agreement with a foreign subsidiary to jointly develop, for example, a new pharmaceutical drug or computer software. The two corporations agree to split the research and development costs. Then at the end of the day, each corporation owns a portion of the jointly developed intangible. Typically, the U.S. corporation will own the right to exploit the intangible in the U.S., and the foreign corporation will own those rights outside the U.S. So the issue in Altera was whether stock options issued to employees was a cost that the U.S. corporation had to share with its foreign affiliate. If the U.S. parent's cost of stock-based compensation has to be shared, that means the foreign subsidiary has to pay the U.S. parent for its share of that cost. And that payment means more income and more tax to the U.S. company. Many taxpayers that enter into cost-sharing agreements with foreign affiliates don't share the cost of stock-based compensation. That's based on the view that an unrelated corporation entering into a comparable agreement would not agree to share the cost of stock-based compensation. It's because stock options are, inherently difficult to value. Because the cost of an option depends on the value of the company's stock when the option is exercised at some point in the future. So sharing those uncertain costs can lead to disputes. So the basis for excluding stock-based compensation from a related party cost-sharing agreement is that unrelated corporations bargaining at arm's length would not share those costs. The IRS disagrees with that view. In 2003, the Treasury issued a regulation explicitly requiring affiliated parties to a cost-sharing agreement to share the costs of stock-based compensation. And the issue in Altera was the validity of that regulation. So the tax court in 2015 found that the Treasury's regulation was invalid. Altera did not have to share the cost of stock-based compensation with its foreign affiliate. The tax court took issue with the Treasury's proffered reasons for the regulation. The Treasury said the regulation was based on its view that unrelated parties would share the costs of stock-based compensation. Therefore, related parties must do the same thing. The tax court found the Treasury's conclusion was not based on reasoned decision-making. The regulatory file showed the Treasury didn't conduct an investigation to figure out whether unrelated parties would share the cost of stock-based compensation. And the file didn't contain any examples of related parties actually sharing those costs in the real world. Instead, the Treasury's reason for the regulation was simply an assertion that unrelated parties would share those costs. The tax court also found the Treasury didn't adequately consider examples of comparable related party transactions submitted by commentators. those comparables were evidence that unrelated parties would not share the cost of stock-based compensation. And the problem with ignoring all those comparables, as the tax court saw it, was that the arm's length standard has to be based on what unrelated parties would do. Because the Treasury's regulation did not adequately consider what unrelated parties in comparable transactions would do, the regulation violated the Administrative Procedures Act. So the decision was signed by 15 of the tax court judges with no dissenting opinions. So the government appealed the case to the Court of Appeals for the Ninth Circuit. So first let's pause and just talk about why the Ninth Circuit. So the tax court is a specialty court that handles appeals of deficiencies issued by the IRS. The court's judges are tax specialists, and importantly, the court has nationwide jurisdiction. Tax court decisions are appealable to the U.S. Circuit Court of Appeals that has jurisdiction over the geographic area that the taxpayer's principal place of business is located. Altera was headquartered in California, and the Circuit Court of Appeal with jurisdiction over the area that includes California is the Ninth Circuit. So Altera's tax court decision was appealable to the Ninth Circuit. So a three-judge panel of the Ninth Circuit heard the government's appeal and reversed the tax court, holding the Treasury's regulation was valid. And what's notable about the Ninth Circuit's decision, and this was the focus of the dissent's criticism, is that the court held the regulation was valid on a basis that was different from the basis articulated by the Treasury when it promulgated the regulation in the first place. The Treasury's stated reason for the regulation was its view that unrelated parties would share the cost of stock-based compensation. But on appeal, the government argued that it didn't need to look at comparable transactions at all. It could satisfy the arm's length standard by simply looking at all of Altera's costs. And for that reason, it wasn't relevant. The Treasury didn't defer to comparable transactions submitted by commentators when it initially proposed the regulation, showing that related parties did share stock-based compensation. Did not share stock-based compensation, rather. That's because the Treasury wasn't even using comparable transactions to determine the arm's length price. The decision shocked a lot of practitioners. Using comparable transactions as the basis for evaluating the arm's length standard has really been the keystone of U.S. transfer pricing for decades. And it's also the international consensus for taxing related party transactions. So upholding the regulation, the Ninth Circuit's decision upholding the regulation on the basis that the Treasury didn't even need to consider comparable transactions was seen as an extreme departure from the arm's length standard. So Altera petitioned the Supreme Court to hear the case, and on June 22nd, just a couple weeks ago, the court declined to take the appeal. So as a result of the Supreme Court declining to take the appeal, the Ninth Circuit decision has become final. So even though the Altera case is final, the validity of the Treasury's regulation is not yet settled. Other taxpayers are likely to challenge the Treasury's regulation in courts other than the Ninth Circuit. This is possible because the Ninth Circuit's decision isn't binding in other circuit courts. It's not even binding on the tax court. So the question that comes to mind after the Ninth Circuit's decision became final, and I'll turn it back over to Kyle for this, is how persuasive is the Ninth Circuit's reasoning going to be to other courts considering the validity of the Treasury's regulation?
Thanks, Sebastian. And all of this matters, by the way, for state tax purposes, because the fact that the Ninth Circuit may think one thing and other circuits may think another has a significance, we think, for state tax purposes, which we'll explain in a minute. So hang in there with us. So what you may think, though, is that if the Ninth Circuit decided against Altera, won't the other circuits just do the same? And our answer to that is not necessarily. First, you have the unanimous decision of the tax court, essentially a 15-0 decision on a type of question that falls right at the heart of its expertise. Second, you've got a close call at the Ninth Circuit. You've got a 2-to-1 decision over an enthusiastic dissent. The dissent was not only enthusiastic, but it was the judge that wrote the dissent on the merits also repeated and wrote another dissent on the court's refusal to hear the matter en banc. And then, and that's what this slide depicts, you have the Ninth Circuit's track record, which we think helps show that the Ninth Circuit doesn't see the world quite like the other circuits. For example, my circuit, I'm here in Philadelphia, the Third Circuit, gets reversed about half the time. When cases are called up on review, the reversal rate is about 55% or so. But by contrast, the Ninth Circuit gets reversed 3/4 of the time when its cases are reviewed by the Supreme Court. Now, of course, the Supreme Court decided not to review the Altera case, but I think that this graph shows that the Ninth Circuit's thinking, when tested by the Supreme Court, is often out of line with the Supreme Court's thinking and with the thinking of the other appellate courts. So that means we think that the other circuits are less likely to see the Ninth Circuit's opinion as persuasive, and that's on top of the fact that there's a 15-0 tax court opinion going the other way, and on top of the fact that there was a dissent, an enthusiastic dissent, in the Ninth Circuit's opinion. So with that in mind, let me turn it back to Sebastian to discuss the options at the federal level, which again are going to have an impact on the state analysis.
So with all those considerations, the question is, what are taxpayers going to do federally? Let's say you're a taxpayer that's a party to a cost-sharing agreement with a foreign affiliate, and you're not sharing the cost of stock-based compensation. The IRS audits you and it applies its regulation. It makes a huge transfer pricing adjustment. Your foreign affiliate has this huge deemed cost-share payment that's going to dramatically increase your federal taxable income and federal liability. What do you do? As a quick aside, I'll note that the IRS did pause enforcing the regulation after the tax court decision, but it's now instructed its examiners to continue enforcing the regulation. So even if you're not facing the decision today, you likely will in the future. And so the question is, do you challenge the IRS's view that their regulation is valid, or do you acquiesce? Let's say you decide to challenge the decision. Here are your options. You can challenge the IRS's adjustment. This really only makes sense if you're headquartered outside the Ninth Circuit. That's because an IRS adjustment is challenged in tax court. And if you're headquartered in the Ninth Circuit, you'll be appealing your tax court decision to the Ninth Circuit. Now, because your case will be appealed to the Ninth Circuit, the tax court will apply precedent in the Ninth Circuit to decide your case. This is the Golson rule. The tax court follows binding precedent in the jurisdiction to which the taxpayer's appeal lies. So if you're headquartered in the Ninth Circuit, the tax court is simply going to apply Altera, uphold the regulation, and uphold the adjustment. And on appeal to the Ninth Circuit, you would get a 3-judge panel. And although that panel might be comprised of different judges in the panel that considers the Treasury's appeal in Altera, it's not going to help you. A Ninth Circuit panel can't overturn the decision of a prior panel, so the Ninth Circuit is simply going to apply Altera and uphold your adjustment. If you're outside the Ninth Circuit, you can appeal the adjustment to tax court and relitigate the validity of the Treasury's regulation. The tax court may address the Ninth Circuit's reasoning when it decides your case, but it seems pretty unlikely the tax court is going to change its mind, considering the original time that it faced the question over the validity of the Treasury's regulation. It was a 15-0 decision. Alternatively, you can pay the tax and file a refund claim. Instead of tax court, refund claims are filed in U.S. District Court or the Court of Federal Claims. If you file in U.S. District Court, you're likely filing in the Federal District Court in which you're headquartered, which means you'll be appealing to the circuit court that has jurisdiction over the area that you're headquartered. Now, if you file in the Court of Federal Claims, the appeal will be to the Federal Circuit. So no matter where you're headquartered, that means that even taxpayers in the Ninth Circuit can relitigate the case by filing a refund claim in the Court of Federal Claims. Just like any other taxpayer, their appeal would not be to the Ninth Circuit; it would be to the Federal Circuit. With so many dollars at issue for so many taxpayers, it does seem pretty likely that Altera is going to be challenged. Whatever circuit hears the case, an appeal could again be made to the U.S. Supreme Court. The likelihood that the Supreme Court will take the case, increases if another circuit disagrees with the Ninth Circuit and upholds the regulation. All this goes to say some taxpayers are going to continue excluding the cost of stock-based compensation from their cost-sharing agreements and may ultimately challenge Altera in litigation. While there are a number of procedural avenues to do so, some taxpayers may simply acquiesce. And if you acquiesce, you'll be facing increased federal taxable income and increased tax liability. Our view, and the focus of this webinar, is that even those taxpayers who acquiesce should not be paying more state tax now because of Altera. Before getting to that, I'll turn it back to Kyle. What are some reasons that taxpayers might acquiesce to Altera?
Yeah, that's a good question, Sebastian. Who would want to acquiesce? Well, here's the deal. We're not recommending that any of our clients, even those in the Ninth Circuit, acquiesce. If you're in the Ninth Circuit and you're thinking of acquiescing, Reed Smith's federal tax controversy team would love to help. Frankly, we may even take the case on a contingency. The case is far from over. We'd represent you through the Court of Claims and the Federal Circuit and so on. But the fact is, many companies may decide for their own reasons that they're not going to litigate. And we think that's especially true of those in the Ninth Circuit. Their only appeal is to the Federal Circuit, which frankly is one of the more pro-government circuits. Again, we take the case, but the road is harder. Half their options are cut off, and the other half is to a relatively pro-government circuit. But now the companies in other circuits, like those in the Fifth Circuit in Texas, or the Eighth Circuit in Chicago and Minneapolis, the Sixth Circuit up in Michigan, or the 11th down in Florida, or the Third Circuit right here in Philadelphia, they have more inviting appeals courts to look to, and they should definitely continue to fight. And Sebastian, in those circuits, and I don't want to talk for our federal tax partners, but I think we definitely take the case on a contingency there. But in any event, at the end, what that really means, and what's important for the state tax analysis, is that there's a geographic divide between those that are more likely to acquiesce, that is, those in the Ninth Circuit, and those that are more likely to fight. And Sebastian, let's take a look at that geographic divide.
Okay, so you're more likely to acquiesce if your assessment appeal is to the Ninth Circuit. And if your assessment appeal is to the Ninth Circuit, that means you're headquartered in one of the 9 states within the Ninth Circuit's geographic jurisdiction. That's the region shaded in green on this slide. So why does this matter? It matters because states use federal taxable income as their tax-based starting point. Because of the pressures created by the federal procedural rules, the Altera decision means that a corporation's federal taxable income is partly dependent on where it's headquartered. That means its state tax base will depend on where it's headquartered. And that creates a state tax constitutional problem because states can't discriminate, that is, cannot impose unequal tax burdens based solely on where a company is headquartered. To flesh this out a little bit, let's say the IRS assesses 2 companies that are alike in every way, except that one is headquartered in the Ninth Circuit and one is headquartered outside the Ninth Circuit. As a result of being headquartered in the Ninth Circuit, the corporation is going to be facing the pressures Kyle mentioned, and will be more likely to acquiesce to Altera and apply the regulation. As a result, its federal taxable income is going to increase, and its state tax base is likewise going to increase. On the other hand, a taxpayer headquartered outside the Ninth Circuit is far less likely to acquiesce. As a result, its federal taxable income is going to stay the same, and its state tax base is going to stay the same. This creates an unequal state tax burden based on the location of the company's headquarters. And in our view, a taxpayer who is facing an increased federal taxable income as a result of acquiescing to Altera does not need to pay state tax on that increased income because of this unequal treatment. So I'll turn it back to Kyle. Why is this unequal treatment a problem?
Yeah, thanks, Sebastian. Why is it a problem? Well, making a geographic distinction, as Sebastian noted earlier, matters for state taxes because the Commerce Clause prohibits discrimination on the basis of where you're located. So to make this sort of understandable in this situation, let's take an example of a company that's filing California tax returns. That company, if it was headquartered outside the Ninth Circuit, would be unlikely to have acquiesced to Altera. But another company, exactly the same, that's headquartered in the Ninth Circuit, is going to acquiesce, perhaps, or is more likely to acquiesce because it's in the Ninth Circuit. So that means there's a distinction that is made on the California taxation of the company solely on the basis of where it's headquartered. And this runs headlong into the constitutional rules that prohibit a state from treating taxpayers differently based on their headquarters. And it's important to note here, it doesn't matter that the state discriminates against its own taxpayers too, because the fact is this: a state has to be neutral with regard to state geographic boundaries. The court has developed this concept of tax-neutral decision-making, and that means the state can't differentiate based on state boundaries. It can't pick winners and losers based on in which state they're headquartered. And the other thing that's important to note here is the state can't use federal conformity as a defense, and we've cited the Kraft case for this. The state can't simply say, well, there's discrimination at the federal level because of the split in the circuits, for example, on the Altera question, and therefore we can perpetuate the discrimination at the state level. The state must treat every taxpayer the same if it's headquartered in different states, regardless of the fact that there's discrimination at the federal level. Now, Sebastian, even if, sort of perish the thought, a company decides to acquiesce, there are issues a company should consider in filing its unfavorable Altera motive RARs. And Sebastian, can you talk about that for us, and also talk about maybe the impact that some of these other issues would have on computing the provision that a company may need to make?
Thanks, Kyle. So the focus of this presentation thus far has really been why no one should pay more tax as a result of Altera today. We understand that for a lot of companies, the more pressing issue may be, what are you going to do with your provision? Let's say you're going to adjust your reserve as a result of Altera, and you might be computing the state tax component of that reserve as if the Treasury's regulation is valid, and you're going to have to report increased taxable income to the states. There are positions you can take on your return, and therefore consider in computing your reserve that might mitigate the state tax consequences of applying the Treasury's regulation. So we're going to talk about these positions in more detail in a later webinar, but I'll briefly mention a couple of them now. So first, there's a position to include the cost share reimbursement from the foreign affiliate that's a party to the cost sharing agreement in the sales factor. Some taxpayers just miss this because the reimbursement is generally treated as a reduction of costs or the reduction of a deduction on the federal return rather than the inclusion of a gross receipt. Regardless of the federal reporting of the reimbursement on taxpayers 1120, cost share payment from a foreign affiliate should be treated as a receipt for state sales factor purposes because it's really a payment for services. There's also a position to gross up royalties received from the foreign affiliate for the buy-in of existing IP that's used in the cost sharing agreement. That is, you can simply include, if you include just the royalty itself in your sales factor, that might be distortive. To truly reflect how that royalty income is generated, there may be a position to include the sales that were earned by the foreign subsidiaries that are related to and gave rise to the royalty income in the U.S. taxpayers or in your factor. I'll also mention that there is a number of issues around contractual reverse clawbacks in cost-sharing agreements. A reverse clawback is a cost-sharing agreement provision that some parties have included that requires parties to retroactively share the cost of stock-based compensation if the Treasury's regulation is finally upheld. I'll note that if the Altera decision did trigger your reverse clawback, you may be required to recognize income and pay more state tax today. That's sort of a minor exception to the theme of this webinar. But whether you have to recognize reverse clawback income now or in the future, you should consider whether it makes sense to apportion the clawback income using factors, state apportionment factors, from the year in which the cost sharing payment relates, rather than the year that the reverse clawback created an income inclusion. That is, user historic factors rather than today's factors. And as I said, we'll be covering these issues and more in a future webinar. Thanks for joining us today. The takeaway from today's webinar is pretty simple. In our view, no one should be paying more state tax as a result of Altera today. And if you're recomputing or computing your provision to account for the ultimate impact of the Treasury's regulation being upheld by another circuit or the U.S. Supreme Court, there are return positions that may impact the computation of that reserve, and please join us for our future webinar where we talk about these issues. Please don't hesitate to reach out. Our contact information is on the screen. Thank you.